week, every Tuesday morning at 8:05. That is when we do the feature Constitutionally Speaking. And if you recall, last week we took a look at the judgment of the Supreme Court declaring that the states of emergency were unconstitutional. And there were two areas that we dissected with the help, of course, of our learned guest who I'll introduce in a short while, the Deputy Public Defender. We looked at the issue of whether Dr. Dayton Campbell, the person who brought the case, had standing, and also whether the declarations of the states of emergency were in fact made for a purpose as set out in the Constitution. Well, we're continuing on this subject this morning, and we'll be looking primarily at remaining issues, namely whether the declarations were demonstrably justified in a free and democratic society. And we'll also tackle whether the declarations breached the doctrine of the separation of powers. In a conversation with my guest, he did say if time permits, we will also look at the implications for persons detained in those states of emergency. And so, ladies and gentlemen, without further ado, the man with the knowledge. We're joined at this time by the Deputy Public Defender, Mr. Herbert McKenzie, noted attorney at law. Good morning, Mr. Mack. Welcome. How are you doing?
I'm fine, thank you, sir. Good morning to you and to your listeners.
Sorry for making the introduction so long, but there's a lot to say when we're introducing somebody like you.
Thank you very much.
All right.
Yeah. So last week we looked, the court dealt with four major issues.
Yes.
Last week, as you introduced, we looked at two. We're going to try and look at the other two this week. Now, the third issue that the court grappled with was whether the declarations of the states of emergency were demonstrably justifiable in a free and democratic society. And that is one of the requirements of constitutionality under the Jamaican laws.
Mm-hmm.
Now, the court started its reasoning by first recognizing what I call an umbrella provision in the Constitution. It's Section 13 and it's Subsection 2, which essentially says that Parliament shall pass no law and no organ of the state shall take any action which abrogates or abridges or infringes any of the rights enumerated in the Constitution. That is right to liberty, freedom of peaceful assembly, freedom of movement, etc., right to protection, and all those sort of rights. Now, for the court, the Constitution recognizes that these rights are not absolute. Rights that are absolute are like the right to life. But some of these rights are not absolute, in that those rights can be lawfully infringed if it is reasonably justifiable for the purpose of dealing with the situation which exists during the period of public emergency or during a period of public disaster. So the court look at those rights and then identify the ones which are mostly affected by a state of emergency. And I think we all know that the rights mostly affected by a state of emergency are, firstly, your right to movement, because we have all these checkpoints all over the place during the state of emergency, these curfews, these cordon search. Then there's the right not to be deprived of liberty. That's paramount, because under the state of emergency, we all know that the police, law enforcement officers are empowered to take you up and carry you to a center of detention. And thirdly, the right to a hearing in determining your person's civil rights. So if you are taken up, you cannot be held indefinitely, has happened years ago. There is no Emergency Powers Review Tribunal that is also set up coterminous with the declaration of the state of emergency for people who are detained to have give them a hearing to justify whether or not they should be kept in the custody or they should be released. Now, the court examined whether curtailment of these rights by the states of emergency were reasonably justifiable in dealing with the situation. And the situation we're referring to is the situation of the rising crime and the rising violence that obtained then. the court said that while the state can do that, the court must now test for the constitutionality. And the test they use is the same test that was applied in what we call the NIDS case. If you recall, that was a case in which Julian Robinson, a PNP minister, challenged the government's introduction of this National Identification System, NIDS.
Yes, I remember that.
He challenged the constitutionality of it, and he prevailed in that one because the court struck down certain parts of the NIDS law. Well, the test the court used is the same test that the Supreme Court imported and used in the Dayton Campbell case, the one that we're talking about. And the court recognized it as a two-stage test. The first stage of the test is to determine whether or not the law infringes the guarantee rights. I think it's common knowledge that the law does, the state of emergency. So the second phase of the test now is, since it does infringe upon the rights, it is now a matter of determining whether the infringement is demonstrably justified in a free and democratic society. And that was the test that the court brought to the constitutionality of the state of emergency on the challenge of that Dayton Campbell. Before I go into further into the court's reasoning,
yes,
let me point out here that Dayton Campbell, in that case, they refer to him as the claimant.
Mm-hmm.
It was under the law, he had the burden of proving that the state of emergency was unconstitutional. And he has to prove that on a balance of probabilities, not beyond reasonable doubt, like in criminal cases. Once he established that on a balance of probability, it must be the state now. In this particular case, it was the Attorney General who represents the state, as is normally the case, who must establish that the act or the conduct which Dayton Campbell cites or complain against, and which amounted to the infringement, is demonstrably justified in a free and democratic society.
Mm-hmm.
So I think it was not hard for the court to find that the state of emergency did in fact reach constitutional rights. So Dayton Campbell, having established that, and that was rather easy, it was now for the Attorney General acting on behalf of the state of Jamaica to bring forth evidence to justify the imposition. Now, the state brought forth evidence through the police and command, and the court examined that evidence because the original goal or the initial goal or the perpetual goal of the state of emergency was to curb the level of criminal activities, which was undoubtedly out of control, and I don't think anybody can really dispute that. Now, like I said, the evidence came through the police high command.
Yes.
The court examined the evidence. First of all, when the court examined the evidence, the court found, as a matter of fact, on the evidence of the police high command, that there was a 20% increase in murders in February 2023, and there was a period during which a state of emergency was in effect in St. Anne. The court also found, on the evidence presented by the police high command, that during the period December 28, 2022 to January 10, 2023, period in which a state of emergency was declared, and in February 15, 2023 to February 28 in 2023, that there was a state of emergency in West Kingston Division. Yet the evidence from the police itself is that for the period January 23 to February 10, 2023, which is a period that spans part of the state of emergency that I've just outlined above, the West Kingston Division had the highest number of murders and shootings across all divisions. That represented a 31% increase in murders and a 20% increase in shootings when compared to the same period in the previous year. So those are what the court looked at to determine whether or not there's evidence to justify the imposition. Another piece of that evidence from the statistics that the court paid attention to was since 2018, and you recall one of the first state of emergency in the series that have been going on started in St. James in 2018. Since that time, there have been 11 state of emergencies declared, including the extension in St. James. Yet over the very same period, January 1, 2023 to November 15, 2023, which is part of the period in which state of emergency is in St. James. St. James Police Division had the highest number of murders across all police divisions in Jamaica. So the court is saying that on that evidence, you really can't say that the state of emergency was achieving the objective or the goal that it was intended to have. And if it wasn't achieving the goal that it was intended to have, it cannot be demonstrably justifiable in a free and democratic society. Even
if the numbers are proving that there were some degree of upsurge in violent crimes, it seems.
Precisely so. Mm-hmm. Because the aim is to keep down crime. And if the measures you implement are not seeing the opposite, then you can't justify keeping the measures simply for keeping down crime. Because in common parlance, the court is saying it's not working, it's not keeping down the crime that you say or you purport that it should keep down. Mm-hmm. A crucial piece of evidence from the police that the court paid attention to was the St. Anne situation. And the court said that the St. Anne situation provided what is called a glaring example of the absence of any attempt to achieve proportionality. Before I go on, let me just explain this piece of proportionality doctrine.
Yes.
When an action is taken that curtail rights, the action by law taken by the state must be proportionate to the objective or to the mischief that you seek to cure. The court is also saying that there was no proportionality here because in St. Anne, on the police's own evidence, the areas in which there was a rampant rise in crime and violence were Teartown, Mansfield Heights, Parrytown, and they named several other communities. But all these communities were in the northeastern section of St. Anne. Yet the state of emergency was imposed on the entire parish from December 6, 2022 to December 19, 2022, again in December 28 when they renewed it, to January 10, 2023, and then when it expired in January, the lapsing period, and then they reinstated in February 15 to February 20. All those times the court saying that the state of emergency was put on the entire parish when only a portion, relatively small, of the parish was demonstrating exactly this upsurge and this rampant. So proportionality doctrine was not satisfied and was not met. With all of that evidence before the court reasoned that it cannot, as a matter of law, be demonstrably justifiable and that to impose the state of emergency, and the state had not demonstrated on evidence before it that the state of emergency and the consequent infringements or abrogation of constitutional rights was a response that was proportionate to the circumstances. And in that basis, the court held on that issue too that the constitutional the state of emergency declared as they were breach the Constitution. So it needs to be pointed out that the court is not speaking generally for all state of emergencies that are not yet declared or are to be declared. The court is talking about the state of emergency, which Dayton Campbell challenged and brought before the court, and those states of emergency that it considered. Now, the fourth issue that the court, well, let's see with closer time, but let me just introduce it and tomorrow pick up on it and deal with implications. The fourth issue that the court dealt with was whether the declarations of states of emergency breach the doctrine of separation of powers. That's a doctrine in law which recognizes that the government in the Westminster system that we practice in Jamaica consists of three co-equal branches in the government: the executive, the legislature, and the judiciary. Next week, I'll pick up on that and visit the court reasoning on that point or on that issue. And then after that, we look at the implications for persons detained under those states of emergency, which the court declared were unconstitutional.
Yes.
So, more and on.
More and on. We learned a lot more today, and we thank you so very much. I'm finding this very, very interesting, Mr. McKenzie, and we thank you for the information provided. Thank you, and have a good day.
You 20.